Our next panel session is entitled Legal Considerations Impacting the Life Settlement Industry. And we'll feature Lee Pepper from ArentFox Schiff, LeQuang from Oric, JP Schnapper from Schnapper-Casteras LLC, or PLLC, I'm sorry, JP. And will be moderated by Tom Bohack from Troutman Sanders. Tom, I'll pass to you. Thank you.
Perfect. Well, thank you very much. And I think thank you, everybody, for getting in after lunch. I know it's always tough to break off those conversations, but good to see everybody coming back in. So I think we'll start off with just a quick introduction of everybody up here on the panel, and then we'll dive into some of the current things that we're seeing in the market. So I'll start off, Tom Bohack with Troutman Pepper Locke. I'm an asset management lawyer by training, so a little bit different than most of the other conversations we'll have here. But I'll be able to provide a little bit of insight into the SEC regulation and what we're really seeing at a high level in the market on the capital raising side. And then we'll pass it right down, JP.
Sounds good. I'm JP Schnapper-Casteras. Thank you for having me. I'm an appellate lawyer by training, and I write lots of amicus briefs in the Supreme Court and courts all over, and was lucky enough to write an amicus brief on behalf of Lisa in the case we're going to talk about today. I'm a West Coast transplant and excited to be here.
Hi, I'm LeQuang. I'm a partner in the Orange County Office of Oric, Harrington, and Sutcliffe. I've been litigating life settlement issues over the last 20 years, including a case I'll be talking about that JP also referenced, but it's great to be here. Nice to meet everyone.
Good afternoon. My name is Lee Pepper. I'm a partner in the New York office of ArentFox Schiff. I'm a litigator. I regularly represent companies in the financial services industry, investors, securities intermediaries, and we'll be discussing a couple of developments as it relates to estate claims under Wisconsin law, as well as what we call a bank liability motion that's been pending out there, which will impact undoubtedly the securities intermediaries as well as their customers.
Perfect. Fantastic. Well, thank you. So as to start off and really to trail in after some of our panels earlier this morning, I want to talk a bit about the capital raising activity that we're seeing and how the SEC is approaching the life settlement advisors and funds that are coming into play. So unlike some of the cases we're going to hear, there isn't a whole lot that the SEC publicly has been saying in the industry, but they have been engaging, which is incredibly exciting. We've been seeing a lot of, several of our clients here in the audience today who are starting to register as asset managers. You have the broker-dealers who are getting into the space and various different investment products that are coming into being. Historically, the SEC hasn't had a whole lot to do with the life settlement industry. When you're buying and selling a fixed policy, that doesn't trip it. It's not a security. However, as we're adding variable policies into portfolios, that is moving several of the advisors over and into needing to register, which has been an educational experience, to say the least, for the SEC, Division of Investment Management, which is very used to private credit, other alternative assets, but doesn't touch insurance very often. So teaching them this is what the security is, these are what the assets are, has been a really great experience. And seeing the different vehicles that many folks in the audience are putting together as a way to raise capital and get additional capital into the industry has been great. It's, the SEC has been overall very open to it. Again, they're moving slowly. They view this as a new entrant, a new market that has a lot of potential, and that they're hopeful they'll see more of as it comes through. I know over the past couple weeks there hasn't been anything going on because they've been thoroughly shut down. But once that opens up again, I do expect to see quite a bit more. We've also been seeing a significant interest in the private fund space, both domestically and ex-US, down Cayman, Bermuda, Ireland, Luxembourg, and seeing additional capital flowing in. That said, at core, the funds are made up of individual life settlements, and it's incredibly important to the investors to know that the policies that are coming into the fund will pay out at the end of the day. It's a safe asset, typically. It's uncorrelated, or essentially uncorrelated to the market, which is very attractive, especially today. We had Jamie Dimon come out earlier this week kind of prognosticating that we have a 30% chance for a recession next year, and it's ticking up, just given everything going on. that makes equities, even corporate debt, a bit more risky. This is an asset class that could counterbalance that and be added to the portfolio. So we are seeing institutions start to better understand, through a lot of the work that Lisa and other industry participants are doing, what this asset can do. But the big risk is that those policies aren't collectible at the end of the day, and that's a lot of the work that's going on in the trenches here. So, JP, maybe I'll let you give a okay, then let's go ahead. Go ahead, Kai.
Sure, thanks. Over the last few years, there definitely has been an uptick in insurable interest litigation. Most of it has involved insurance companies or estates trying to invalidate life insurance policies that were sold many, many years ago, essentially arguing, recent developments in insurable interest law, primarily under Delaware law, have created problems regarding the validity of those policies. But I'm going to talk about a case that's rather different and is very much an important case in the industry today. It's a case that was filed by Emeritus. It does challenge insurable interest under a policy, but it's very different. It was a policy that was procured or bought by an individual 20 years ago. He sold this policy. He kept it. It was a term policy. He kept it for 20 years, had no intention ever of selling the policy or anything. But when the term policy was going to expire, it had a right to convert it into a permanent policy. And that's a valuable right because, his premiums are going to go up under the term policy by about 10 times, from about $7,000 annually to $70,000 annually. And if he converted it, the premiums, I think they would drop down to about $30,000, $40,000 in the first year and then move up a little bit. But whoever bought it could convert the policy and have a much more valuable policy. So he did settle the policy, and the buyer converted it to a permanent policy. Emeritus processed the conversion and then turned around and filed a lawsuit saying that the new policy was invalid and that it violated Delaware's insurable interest requirements because the owner of the policy was a stranger and didn't have an insurable interest in the insured. We defended that case and argued that a converted policy is essentially the same as the original policy. It's just the continuation of the original policy. So it really doesn't matter whether the owner at the time of conversion has an insurable interest. It's really about when the policy was originally procured. We filed a motion to dismiss the case in federal court in California. The court agreed with us, following a fairly lengthy line of decisions, beginning with a United States Supreme Court decision in the early 1900s, that essentially converted policies follow the original policy, and therefore the conversion didn't create an insurable interest problem. Emeritus, after losing the motion, though, filed an appeal, and that issue is now before the Ninth Circuit. But it's clearly an attempt by Emeritus to try to impose this new insurable interest requirement at conversion, which would have the effect of chilling settlements of term policies with conversion rights. And as many of you probably know, a large part of this market was driven by, really low-cost UL policies. Many of them have been settled over the last, 20 years. But a very, very important and ripe market is the term market and term policies with conversion rights, because they do give you the ability to convert to something that will stay in force until the insured dies, which is essentially what you want and need in this market. So this is a very direct aim at one very clear and specific market of policies that are targets or attractive to the secondary market. And quite frankly, it's very anti-consumer. The effect of this is really to chill and prevent normal people who no longer want their term policies, who now have this valuable contractual right to convert it. And Emeritus's arguments, and they actually solicited an amicus brief from the ACLI, their policy arguments in support of this had nothing to do with, gambling risks or insurable interest at all. They had to do with profits. They were just saying, if you allow this to happen, we price these term policies, with the expectation that policyholders would never exercise these rights and they would let their term policies term out. And that, quite frankly, has nothing to do with insurable interest. So we responded to that, but in addition, we enlisted Elisa to help out and submit an amicus brief in response to this. I enlisted an old friend, JP, to help out with that, and I'll let JP talk a bit about that brief.
Well, thank you for looping me in on this important issue in the first place. I'll just say a little bit more about the ACLI brief, which I think sort of sets some of the strategic context for this case and why it was important to respond. They obviously weighed in support of Emeritus, and they said, yes, this conversion is really a new policy. But they also painted a very different, pejorative view of the whole industry, which I suspect many of you will find to be totally erroneous and insulting. They leaned very heavily on the sort of moral rhetoric, the idea that this is all wagers on human life. This is a long-running fight against the industry. They sort of tried to reframe the history of the industry and talking about this has been a discredited practice for centuries, and let's talk about the abuses of the early 2000s and all the ways that this hurt senior citizens. And as Kai mentioned, they even have this sort of consumer protection argument. I say sort of because it wasn't a very good argument, that allowing settlement and conversion would result in cherry picking and ultimately would increase premiums for consumers. Lisa, I think, rightly made the decision that it was important to respond to that, not just because it says ACLI was wrong, but because most judges and law clerks probably don't have a good understanding, if any understanding, of what life settlement is about. And so if you let the other side sort of set the terms of the debate, it could be damaging, not just in this case, but beyond. So we made three basic arguments in Lisa's amicus brief. One is that the ways in which life settlement benefits consumers. This is our own version of a consumer protection argument, and trying to start with an affirmative vision, not just be responsive and say all the ways that ACLI was wrong. We talked about life insurance as property and how that's all, has all the normal characteristics of property. We talked about the practical upside of life settlement, the ways that it helps everyday people, get an infusion of cash, which could be useful for any number of ways. Gifts, medical treatment, etc. We had to sort of punch back on this idea that it's all wagers, and that ACLI used it as like, oh, you're using actuarial science and probabilities, and it's like, well, what do you think insurance is? That's not macabre. That's just math. And so we felt that was and at the bottom, increasing competition is good for the market. We recognize this in all other industries and all other areas of business life, and it's certain that sort of, we even quoted Adam Smith because I couldn't help myself. The second big argument was explaining to the court, again, assuming they know probably nothing, the ways in which life settlement is already very well regulated and is an established industry. And so we do sort of a bird's eye view on the statutes and regulations in 45 states and talk about the dangers of disrupting that. Like, it would be very easy for even a well-intentioned judge or law clerk to sort of wade into this and accidentally mess things up. And that's, in fact, an argument that a lot of amicus briefs in other cases, in other contexts, make. And then we talked about the New York's 2011 guidance specifically about conversion. And then the third section, which I won't dwell on, is basically responding to ACLI, which I refer to as the body slam portion of the brief, where we talk about all the ways that they're wrong on the merits. There's no authority for their legal arguments, and they just fundamentally confuse stoli at origination and a sale later in the life cycle of a policy. I'll just say one. So that's what I'll say about the amicus brief. Happy to share it. Great plain reading. Just zooming out a little bit beyond the four contours of this case, which is to say something about amicus briefs in general, because this is a lot of my practice is writing amicus briefs in all sorts of issue areas and in all sorts of cases. And I think one role that groups like Lisa can play is really to inform and educate judges and their law clerks about what's happening in the world and how these things actually work. Amicus briefs can play a number of different roles. They can tell stories, they can share new legal arguments. This is really sort of a practical and a policy brief. Like, this is what's happening in the market, you should be aware. Now, obviously, LISA represents its members. It has, to a certain extent, economic and associational interest in explaining that, as do all trade groups. But I do think that is a really important role to play. And just to set it in context, that other groups, as you probably know, do this as well. I mean, the Chamber of Commerce, the U.S. Chamber of Commerce files 200 amicus briefs a year. The American Insurance Association files about 30 or 33 amicus briefs a year. And ACLI, from my rough math, has filed about a dozen in the last 5 years. So this is not, there's a broader strategy afoot, certainly on the other side. We can talk about that more. And there are sophisticated ways that amicus briefs can be used in terms of choosing cases, building coalitions, sort of thinking about multi-layer. This one was in the Ninth Circuit, but they could happen in other courts. It could happen at the district court level, and even there's some of the big groups have a press strategy. If you're trying to paint your opponent to look like a bad guy, you can use an amicus brief to do that. You can feed it to reporters, and so there's a bigger bottom line. I think is amicus briefs like this can play a useful strategic role. I hope it did here, and that's why I think it was very valuable for Lisa to weigh in.
Fantastic. And before we jump off, Kai and JP, I have one question. Both of you mentioned the gambling argument that I frequently get from regulators as well. I know you guys are really in the trenches dealing with essentially a single policy more often than not. Is this a STOLI? Is it not? Often when I approach that from the investor side, we're not dealing with a single policy. We're dealing with a pool of assets. We're buying 500, 1,000, 2,000 policies that are here. And we frequently use that argument to the SEC or whatever regulator that, of course, this isn't gambling. We've created a very diversified portfolio. Each of these policies is unique. Each one, by its very nature, it's tied to an individual life. And that frequently, almost always, does away with that question at the regulator level because they get it, right? We're not buying one. We're buying 1,000. Law of large numbers. Does that come up at all when you're dealing with, a case-by-case basis?
Sure. I mean, the term gambling in the context of insurable interest is really a term that's used as the opposite of it. If a policy is lacking insurable interest, or more technically, if it's procured by somebody without an insurable interest, courts have referred to that as gambling. I actually think that's a really outdated concept and principle and terminology. It was really intended to cover things back in the day where people were gambling essentially, literally on people's individual lives, like, royalty, like literally betting on when the queen or king would die, and that was considered, improper. But today, when you're settling a policy, that's really not at all gambling. And whether it's one policy or 1,000, it's really just reflective of the investment today and the world today, which is just very different. People are not buying a policy, whether it's one or 1,000, because they're literally gambling on somebody dying. It's an investment that's based on mortality or longevity. And that's not gambling, that's the insurance industry. So I don't think it really matters whether it's a large number issue or not. I just think it's rhetoric that got picked up in some old case law and that insurance companies carry today. I do think it's about time we shed that language, and I've actually enlisted scholars and people to start writing a bit more about how the world has changed, and we view a lot of things differently today than from how we viewed them 100, 200 years ago. As reflected in a number of Supreme Court decisions that show these changes in values. And life insurance companies and insurance companies overall have changed the way they market and create life insurance products. And we're just a long way from, bets on the Queen of England and things like that.
I think that's very well said. The only two things I'll add, I do think the securitization, the sort of diversification piece does help. just put a whole different frame on this. The only thing I will note is that ACLI had this sort of snarky line in their brief saying essentially the same people who brought you mortgage-backed securities have now brought you this, which obviously we have a strong response to, but I do think, depending on the case, you need to be careful about not walking into that and describing it in a way that is still helpful. And I agree, yeah, in the long run, I think the gambling rhetoric is not going to get them this far. It's really old cases, and wait until they hear about all the other forms of gambling that are now legal in terms of sports gambling, crypto, and poly markets. So I think you just have to go back to these are property transactions, these are secondary markets, period.
Not to mention fantasy football, which we all love.
Fantastic. No, thank you. And then, Lee, I know you have two cases out of Wisconsin, Gold and Mecklen.
That's correct. Thank you. I appreciate that, Tom. So as many of you know, estate claim cases, I'm sure many in the room are familiar with it. It's the family of an insured who has passed away. They are now bringing a lawsuit post-death after the carrier has paid out the proceeds of the policy because they're asserting under some states' law that the policy lacked insurable interest, and they're seeking the proceeds of that policy. Not some piece of it, all of it. Whole thing. So anyway, I'm sure there's been many presentations on Delaware law, and there's a lot more case law there than some other areas. But the plaintiffs' attorneys have now been branching out into other states' laws where some other programs were running during the early 2000s time period. So I want to speak with you about two cases that were recently decided this summer on summary judgment favorably for the investors there under Wisconsin law. So just to take a step back, Wisconsin has a different insurable interest statute than Delaware. A policy that lacks insurable interest is not automatically void, and in order to obtain the proceeds, you have to be equitably entitled to them. So when you think about that, what does that mean? If you are involved at the outset of putting a transaction together, you're signing your name off on this, you're making money on it, and putting this policy out into the marketplace, then courts have been finding in both Estate of Gold and Estate of Meckling, no, you are not equitably entitled to this, and we're going to award the proceeds to the investor, the beneficial owner of the policy. And that's essentially what it came down to in both Gold and Meckling. In Gold, you had the insured and her son, who happened to be in the insurance space, take out a premium finance policy. They never expected to keep it, made some money on it, and then ultimately, when the court was weighing everything on summary judgment, found, no, you're not equitably entitled to this. That was decided in early July, and then just a few weeks later, in the District of Connecticut, the Meckling decision came down. Similar sort of analysis there in terms of figuring out Wisconsin law applies to this, but you were involved in putting this policy out into the marketplace. You had signed off on all of these things, so you are not equitably entitled to the proceeds of this. So the estates in both of those have lost. Those cases are now going to go on appeal to the Second Circuit. However, the reasoning is sound. The rationale makes sense. If you are taking part in this, you are putting these policies out into the marketplace, why should you later get to come back and say, I deserve the full entitlement of the proceeds out here? It doesn't add up. Now, that makes sense under that statute because there's this equitable entitlement component to it. Some other states don't have that. So that's where you have a differential between certain lawsuits that are being filed by estates in the state of Delaware, which doesn't function like that, or here like Wisconsin. So that also feeds into the next consideration, what I'm going to talk about, the bank liability motion. So when I say that, I think a number of folks in the room and probably certainly on the panel know what I'm talking about. But in many of these estate cases, the estates have filed suit solely against the securities intermediaries who are the record owners and record beneficiaries at the insurance company level, because in one instance, they might not know who the beneficial owner ultimately is, and in the other, there might not be jurisdiction over the beneficial owner. So they're going after the securities intermediaries for the proceeds of the policies, even though they're functioning solely in their role as securities intermediaries pursuant to a securities account control agreement where they're taking directions from their customers, and the proceeds of these policies are never actually theirs. It's not their money. They're receiving it solely for their entitlement holders and then immediately crediting these policy proceeds to their entitlement holders' accounts. So the case I wanted to talk about there, it's pending in the District of Minnesota. We refer to it as Bogus. It started as a much more convoluted case where 9 insureds, or 9 estates, I should say, filed suit against Wells Fargo Bank and US Bank. Over the course of time, certain estates settled out, certain dismissals occurred, and then certain lawsuits were brought against the entitlement holders in another jurisdiction. So now we're down to 3 estates that are left there. And there's really 2 components to this. The first is, number 1, is a securities intermediary liable for the policy proceeds under Delaware law if it's functioning solely in its capacity as a securities intermediary and immediately credited those proceeds over to its entitlement holder. And then the second component, which is really interesting, is a claim under the Delaware Insurable Interest Statute against securities intermediaries barred by the National Bank Act. It's a preemption argument for the lawyers in the room, but we'll get to there in a moment. So taking a look at this from a high level, what are the arguments as to that first component? It's pretty simple, and the judge we're in front of, Judge Frank in the District of Minnesota, decided on a motion to dismiss earlier this year as well. That's called the Capelli case, and their Wisconsin law, which we touched upon a moment ago, was involved. And he dismissed U.S. Bank in its capacity as securities intermediary on a motion to dismiss for a couple of reasons. First, he found that the Wisconsin UCC, which the securities intermediary was operating under, provided a defense to the claim under Wisconsin law. But he had a very key footnote there saying, to the extent that U.S. Bank received these proceeds, they immediately credited them to their entitlement holder, and as a result, I wouldn't be able to force them to disclose the proceeds because they don't have them, right? It's a very simple concept, and that really is a concept in bailment law as well, and that really colors our argument here in front of the, in respect to the Bogus action. So you have a couple of components to this. Number 1, do you have a UCC argument because these SACAs, the securities account agreements, are actually all governed under New York law? Should that be the law that applies to a UCC defense, even though the Delaware courts have said the Delaware UCC would not apply? That's number 1. Number 2, there's a recognition that they don't have the proceeds. They immediately credited them to their entitlement holders. What are you asking them to disgorge here? They're operating in their role as a securities intermediary, and they shouldn't be liable for that. And then you have another component there where you could say the Delaware courts, even though they said that the UCC would not apply under their insurable interest laws, they also acknowledged in the Malkin decision, presumably if the securities intermediary passed all of the proceeds on to their entitlement holder, they would not be liable. So you take this total mix of information and the facts of what actually occurred here. The securities intermediaries that are left, Wells Fargo and U.S. Bank, it was never their money. They immediately passed it on to their entitlement holders. Why would they be forced to disgorge these proceeds that they don't have and they never had in their personal capacity? So that's the first part of that argument. And then the second part is the National Bank Act. The National Bank Act provides, and I'm paraphrasing here a bit, that if you are functioning as a national chartered bank, you are allowed to engage in other functions incidental to that. The financial intermediary function would fall under that umbrella, and a state's law cannot impede on your functioning as a national bank that would otherwise disrupt your daily activities, etc. So if you have a state's law here, which presents a problem to your solvency, a disruption in your daily activities, or something like that, it should be preempted under the National Bank Act. So those are the 2 arguments that have been presented to the District of Minnesota. We had oral argument on that at the beginning of September. Judge Frank there had indicated we would have an order within 45 days, although our local counsel has advised, don't hold your breath. So we'll see if we have something by the end of this year or perhaps the middle of next year, something along those lines. But let's talk about the practical impact regardless of what the outcome is here. I assume most investors in the room have contracts with securities intermediaries, right? As a function of what's going on here in the very active estate claim case world, these securities intermediaries are getting sued left and right. It's getting very expensive for them in terms of discovery, litigation, and the potential of liability. How does that impact your investors? Well, they're going to seek indemnity from you, of course. So those requirements might go up as the number of state cases have been filed. To the extent they're not liable, maybe that will cause this to go back down, and they'll stop getting named as defendants in these actions. And because they have no liability, they'll have to pursue claims directly against the entitlement holders. So a couple of components to that. A, they might not know who the entitlement holder is, or B, you might be dealing with an offshore fund. So then you get into the role of jurisdictional issues. Can they even pursue a claim like this against an offshore fund? And if they can't, then perhaps they cannot pursue a 2704B claim period under the Delaware law. So there's a lot of practical components to all of these decisions. It's still netting out right now, and we'll see where this goes. But from a day-to-day basis, as you think about your relationships with your securities intermediary and how the securities intermediaries feel about this themselves in terms of having time, energy, employees getting deposed left and right, and disrupting their day-to-day functioning, there's a lot of weight in terms of this decision and what it could do for the marketplace and how it will impact things. So certainly as we think about that, it's something that all of you should consider as well. I think it's important for the investors, it's important for the banks, and hopefully we get some guidance here from the District of Minnesota that's favorable. And then if we get a favorable ruling there, that might go forth into other jurisdictions as well, and we might be able to cite to that, rely upon that, because this motion is coming up in various litigations. It's being asserted quite frequently now by the banks. And certainly, you know, to get a favorable decision here would aid in all of those existing motions, and certainly would set the tone going forward in terms of getting more favorable case law in other jurisdictions as well. So I think those are the high-level considerations, but I'm happy to answer any questions you have about those.
Well, I'll add one in first, and then we
Sure.
can turn it over. So going back to Gold and Meckling, you mentioned that Wisconsin has the equitable defense. You know, they clearly had unclean hands. They participated in the transaction. They shouldn't get recovery. But you mentioned that wasn't all states.
That's correct.
So if we were to play out the same scenario, where, let's take the egregious one, the son is involved, he's an insurance agent, is very active in setting up the settlement, he knows what he's doing, how would that play out in a state that doesn't recognize the equitable prong is right in the statute?
Certainly, that's a very fair question. I think from a fairness component, you would say, well, they shouldn't recover anything, but other states have been reluctant to do so, where it's more automatic. Delaware has been very challenging. I'm sure other panels have appeared before you and have shared the negative case law that we've gotten there. Delaware would be much more of a challenge in terms of their, you know, law and how they have made various rulings on cases like this, where we've been able to show facts not necessarily dissimilar to that, perhaps even more egregious than that. And the courts have been reluctant to go there, and they've been awarding the proceeds to the estates. So Delaware has been very challenging. Other states, you know, it's a nascent area of the law, right? You have a relatively large body of law in Delaware, but you just see the first of the estates cases being filed under New Jersey law, a little bit of Minnesota that we've seen so far. So they're branching out into other areas where there's the time and the place to make those arguments that, you know, just because Delaware has gone one way doesn't mean you should be going this way. And, you know, we'll find out. It's an interesting time from the litigator's perspective as the law is developing. From the investor and bank perspective, it's a stressful time, not knowing what's out there and what the law will ultimately be in these various jurisdictions because it's being developed. But ultimately, I think you need to be prudent in terms of, you know, diligencing these policies, understanding what you're dealing with here, and recognizing that there will be further and future developments under various states' laws.
No, thank you. And maybe we'll turn it open. You know, we've heard a little bit about what each of us are looking at. If there are any questions in the audience, otherwise we can keep going for a little bit as well.
Anyone? So this gets into the securities intermediary. You talk about some of the jurisdictional advantages of offshore funds for you know, if you can prevail with the defenses of the securities intermediary and knock them out of the box, as an asset manager, if you have assets that maybe are at risk, are there structures, whether they're offshore or other types of things that you could foresee that could be advantageous for the managers to set up ahead of time?
So I think it's a very fair question, and it's something that should definitely be explored in terms of what you can do, in terms of, and I would also add, you know, what other jurisdictional components in your various funds are already out there. Is this something that will be successful for you down the road, or is jurisdiction over a particular fund potentially already established to a certain extent where, you know, you're a little late to the game? But I think it's worth investigating, and I certainly think if you get a favorable decision here in terms of the bank liability motion where there might not be jurisdiction over wherever the policy proceeds are sent, I think it's worthwhile to explore that.
Yeah, one additional consideration you may want to take and give some thought to as well. While you may be solving an issue here with respect to the securities intermediary, there will be significant tax and other other considerations in play as you're trying to offshore the fund and what your investors will be looking to do. Several U.S. domiciled may not want the additional tax burden as you're shifting to Ireland or to Cayman or to Bermuda. Okay. Okay. Well, it looks nothing here, so I'll keep going. So at the you're going to get stuck with me. I don't know if that's good or bad. So on the Emeritus case, what do you see kind of looking into the crystal ball going forward there? What can we expect?
Yeah, so we are fully briefed, and we're waiting for the Ninth Circuit to schedule oral argument. We anticipate that will be scheduled for some time in the next few months, so probably early next year. I knock on wood, find it hard to imagine that the Ninth Circuit's going to reverse the trial court decision. I think that what we're really seeing here is Emeritus taking a run at legislating through the courts. I think if the lawmakers wanted to impose an insurable interest requirement on a conversion, they've legislated conversions, they've legislated insurable interest, they've legislated life insurance quite thoroughly, and there's no statute that requires it. The one insurable interest statute requires insurable interest at the time a policy takes effect, and not after, not at any time after. So this policy really did take effect when the original insured took out the policy. That policy carried with it a conversion right. It inhered in the contract itself, and the owner had the right to convert. The owner has a contractual right to convert. So once, and there's actually a California statute that says to protect life settlements that anybody who is assigned a policy, anybody who's transferred or settled, acquires a policy, has all the rights of the original owner. So that right, this right of conversion, is a contractual right that goes with the policy when it's sold. So I frankly think this has been legislated. I think the legislature has spoken quite clearly that this contractual right to convert transfers with the policy. And there is no new insurable interest requirement. It's an ownership right that transfers. So, I'd like to think this will be a pretty straightforward argument. I found that the trial court really understood the issues and gave a quite thorough opinion. So I'm optimistic that this will be resolved favorably. I don't know that that'll be the end of the issue because I think Emeritus will take runs in other jurisdictions. I was actually quite surprised that they took a run in California. There are, I think, other states that would probably been easier for them. So I was quite surprised about that, and I think it was a favorable setup for us on this. But I would imagine they'll take some more runs in other states after this.
What's their ultimate motivation, just to dampen the practice? Or?
Yeah, I mean, so. And by the way, I should have mentioned this. This case law isn't the only forum this battle or issue is coming up. Some of you may have heard, but anecdotally I'm aware that the insurance companies are collaborating behind the scenes on this very issue. And they are terminating agents who process conversions if they find out that within a couple months that converted policy is settled. They'll notify the agent that they violated their life settlement restrictions or violated STOLI practices, and they'll terminate the agents. And so they're cutting off, their whole goal is to cut off this whole line of supply to the secondary market and really the rights of these consumers to settle their policies. If I can, take out this right, this extreme, and by the way, and we mentioned this in our briefs, but this is like a heavily marketed right. You pay for it in a term policy, so it's marketed as a valuable right, the right to be able to convert it to a permanent policy. And they know it's a valuable right. They just also know most consumers, and this is why part of this industry and market exists, most consumers aren't aware of their rights. And once they learn about their rights, they exercise these rights, and the insurance companies don't like that. So they do whatever they can to try to cut them off in different ways. So courts is one forum we're seeing it, but they're definitely dealing with it at the agent level too. And when they terminate agents, agents are deterred from educating clients about conversion rights and settlement rights. And so it's a wider, broader issue beyond just this case.
Thank you. It looks like right now it's pretty exciting time in the legal field and life settlements, right? In Delaware, you have 3 issues, like, statute, premium upset, issue of SI, going after Apollo GP and whatever. You have Maritas going to circuits. If you look down the road, say like in 3 or 5 years, do you expect the field to be as contentious as it is now? Or do you think we'll have more clarity and there is less likelihood that we'll have Delaware issues in other states? Thank you.
A number of questions packed in there. So let's take it down from what I think we will have some clarity on. You're going to have clarity on the statute of limitations issue, right? Probably by Q1, something like that. We think next year. So you'll know that. That's pretty easy. The premium offset issue, certainly a case just needs to be teed up, and it's going to go to the Delaware Supreme Court. I'm hopeful that it happens sooner rather than later because you need to have some clarity around this, right? Because I think if you do have clarity around this, it will either dampen estate cases in terms of them being brought, because a number of these policies might be underwater, so then they recover nothing. It's very simple if that's the situation there and there is full premium offset. At the very least, you'd be able to better function in terms of understanding what a settlement might look like there. Right now, you're not quite guided by anything from the Delaware Supreme Court yet. So I think that will provide some clarity in terms of navigating the Delaware case law generally on those 2 very important issues, as it really dictates what we're dealing with, and the SI issue that I mentioned earlier today. So I think in the next couple of years, are you likely to have more clarity on those? Sure. Is it possible you get some decisions that are, not a model of clarity that present some sub-issues there? Sure. That's often happened in some of the Delaware Supreme Court decisions that we've had over the years, and that's why these cases have kept going up to the Delaware Supreme Court. It's like, well, you handled this issue. What about this issue? What about this point? So there might be some of that on the tail end of this once we hear some of that. So that's a very fair concern. As to other jurisdictions, I think there is this question as to how much do the plaintiffs' lawyers, who are really driving this whole thing, certainly on the estate case space, because it's on contingency, right? That's why they're doing this. They're generating it. I don't think the estates know anything, but for the fact they get a letter, hey, you've already made hundreds of thousands. How about millions? Doesn't that sound enticing, right? And you're not going to pay for anything. We'll just take our contingency cut of this at the end of the day. So I think there's definitely going to be the sort of cases probably where they're willing to venture into some jurisdictions or other states' laws that are not as well developed, where it might look promising, or there's the chance where you'll have a test balloon type case. Let's find out. Let's take it all the way up and see where it goes. Maybe this will be fruitful for them, or maybe it won't. But do I think there will be some of that? I certainly think so. Based upon the fact that they're starting to sample out a little bit into Wisconsin right now. You have a case under Minnesota law now. You have a case under New Jersey law right now under the estates. So are they willing to try it? I think so. I think it would be surprising to me if they didn't, at least file one. I don't necessarily know if they'll file 100, in one of these other jurisdictions, but to find out, is this a favorable jurisdiction for me? Is this a source of new business for me to make a bunch of money? So I think that's, at least my view of the world in terms of where it might be. I think you will have clarity on certain issues that are already teed up, for sure. And I think, there will certainly be additional cases out there where they try to keep pushing the limit. And we'll see what those decisions look like. But I think from at least the defense side that we're all on over here, if we're able to, cabin certain states as, okay, these are certainly the problematic ones, but get successful decisions at those state high courts in terms of the law, or make it, favorable, something like a Wisconsin or something like that, then that would be an excellent result for the entire industry.
So I can chime in a little. Yeah. So I would definitely agree with Lee on all that he has said. I would just add that I find Delaware to be unique here and fairly contained, not just because of the law that's developed, but also historically a lot of programs that are alleged to be stolely were designed to be governed by Delaware law. And so you have a higher concentration of litigation in Delaware by virtue of that history. You have seen efforts to bring estate claims and expand these theories into other states have largely failed. I think Wisconsin is a recent run, and I can understand why, because there were some premium finance programs that specifically sought in the application of Wisconsin law. But you don't really see that a lot in other states. I can think of a premium finance program that was designed for California law because certain aspects of California law, there's no estate claim in California. So, they're not going to try to bring those types of claims. So there is like a various factors that go into whether there's going to be risk in a particular state. Delaware just reflects, I think, the convergence of a number of factors today that create that risk, but I don't think it's a huge, broader risk for that reason.
And
Lee, can you comment on the case you're handling down in Georgia?
Sure, I'll speak to that a little bit. So the case that you're referencing, that's the Leone action. That's another Emeritus case. Actually, they've been very active in the marketplace and challenging policies recently. So the Leone case it was under Georgia law, and there were certain certified questions that were sent to the Georgia Supreme Court. That argument was held in late August. My partner, Jules Rousseau, who was sitting here a moment ago, handled that argument, and it was building upon certain, I guess, uncertainties in other Georgia Supreme Court decisions in the last few years. So they're building upon that, answering some, uncertain questions. And that's kind of what I was alluding to a minute ago. You get these high court decisions, maybe they leave an open issue, and then they have to go back, re-clarify. You go back up to the, state's highest court there. So my takeaway on that, at least reading the tea leaves from the argument, was that the Georgia Supreme Court, in particular the presiding justice and others that were there, based upon the argument we're watching there, they seemed very much in line with their prior holdings there and favorable to the investor's position as we asserted it. The Emeritus lawyers kept trying to drill back to some of the factual findings in the decision below that certified the questions, and I think got scolded multiple times by the presiding justice and other justices from the Georgia Supreme Court. And it just, based upon the argument, it seemed very favorable to the investor side argument. We'll have to wait and see. An argument doesn't necessarily dictate what the ruling's going to be. Hopefully that's, again, something that will be, filed by the end of the year. We're hopeful. It was, I think, August 20th, thereabouts, when the argument was held. So again, that's a question under Georgia law. There were certainly programs running in Georgia. So I think that will be insightful in terms of, both the carrier and estate side cases, depending upon what the Georgia Supreme Court rules there, and provide some further clarity as to what the Georgia Supreme Court is going to hold in the future.
Hi. We sit in a lot of boardrooms with compliance officers, and they'll only make a decision really based more on a little bit of fear of maybe not disclosing this option if it was required. Do you see any opportunities for whether it's, I don't know if I use the word class action too much, but to say, are you 65 and older, 70 and older, have you canceled or lapsed a policy? Because that tends to drive the hundreds of thousands of advisors that don't want to get caught up in some type of breach. Can you see that being profitable for firms like yours?
An interesting question. I don't think we've, looked too deeply into sort of class action measures here one way or the other. It's something I think you can certainly consider and talk about it and think about that. It's certainly as it comes from the investor side here in terms of the number of policies that they're holding, et cetera. So I think it's something worth considering. I think it's a question as to who you're bringing the class action against, whether it's carriers or something of that nature. So I think it's worth looking into. That's what I would say.
No, and it is definitely a good conversation to have with the wealth managers as they're looking at their high net worth clients or at their clients. This is a viable option. They're fiduciaries to those clients, and just really it's an education campaign, which I know you've heard several times here today. But as the life settlement industry becomes more, of a common, dinner table, conversation, people know what it is. I think that's where you'll start to see more clients asking their advisors about this. the advisors having to go look it up, reach out to you guys, and that would start just organically driving it because it is a good value add to the ultimate client at that end.
Any more questions, or let me keep going?
Along those same lines, the few states, I believe there are 9 states that require the insurance companies to inform consent to the policyholders for life settlements, about making that across the entire country.
Well, I'll just say that the insurance industry has an incredibly strong, lobbying force out there, and I think that's a testament to that strength there. Because there's a lot of work to do to try to get more education and visibility into the life settlement option. I'll frankly say that over the last 10, 15 years prior to these estate claims, I had a hope. I have a hope still too that this market will very soon be a lot more recognized and appreciated and valued. I just think there's a couple bad actor companies out there. You've heard the name Emeritus, countless times already, but you've seen a lot of them drop off. There was a question about, class actions and things like that. There were individual suits against one carrier 10, 15 years ago. You all know the carrier, probably Phoenix, but that really were directed toward conduct that was intended very specifically to impair the secondary market. And we ourselves brought an antitrust claim against Phoenix that was tethered to their conduct to monopolize the secondary market of their own policies by essentially forcing lapses. So by taking steps, raising COI rates, denying death benefit claims, bringing rescission actions, and doing a host of other things that they were doing, making kind of frivolous arguments about chain of title and things like that, all were designed to deter settlement companies from acquiring their policies or entities from trading them into tertiary markets so that they couldn't essentially be lapsed. And I think the result of that was a settlement, but I don't think there were other companies like that. I would say Emeritus is bordering on that today. But by and large, many of these insurance companies are not as visible in that action. So.
We have time for one, maybe two more questions.
I'll just, to dovetail on the class action question earlier, I mean, the other thing that, speaking only in my individual capacity, of course, I mean, the other thing that's rubbed me the wrong way is that is this practice by life insurance agents of them being canceled or deplatformed for simply informing their clients that this is an option. I mean, that just as a matter of principle, that seems anti-competitive, and like it would be a very bad set of facts for the other side to have to defend. So that's if I were just spitballing, that's another avenue of attack. I don't know if all those agents technically have fiduciary duties in certain states, but it's a bad set of facts.